Good morning. Appreciate your accommodation with the first case that was scheduled being canceled, so hopefully you didn't start your preparation thinking you had half an hour this morning to do that, so, but I doubt you did that, so.
SJC-12859, Bank of New York Mellon v. Alton, King, and another. Good morning, Your Honors. May it please the Court.
One second, Mr. Morello, wait till we get all scheduled, and then we can start your clock and we can get going.
My apologies, Your Honor.
No worries. Okay, now.
Okay. Good morning, Your Honors. May it please the Court. I'm Carl Fumarola, and with me today is Christine Kingston on behalf of Bank of New York Mellon. The issue before the Court is whether a party in a post-foreclosure summary process action can be required to pay the fair value of using and occupying property after a judgment for possession is entered in order to pursue an appeal. The answer to that is clearly yes, based on the plain language of the applicable statute, which is consistent with fundamental property rights and the long-standing practice of housing courts that apply these statutes daily.
Right, but the language is pretty clear, isn't it, in both statutes? One specifies rent, nothing specifies any other kind of payment for a foreclosed home.
Your Honor, they both specify rent.
Oh.
So
Where in Section 6 does it say rent?
Section 6 says rent pay fair rental value of the property. It does. And so that's my major point today. In order to understand what the housing court did is correct, the issue is very simple. The parties' briefs may contain a lot of distractions, make the issue seem more complicated than it is. But to understand what the housing court did was correct, all this court has to do is interpret the word rent consistently.
Can we go back to Justice Seifer's first question, though? It's not as simple as that. Section 6 says as rent, and the suggestion is that the 5E amendment was limited to a landlord-tenant relationship. So I'm not so sure the answer to Justice Seifer's question. You might be right, but the answer is certainly not as simple as you just made it.
In two adjacent sections of 239, Section 5E and Section 6, the legislature uses the term rent. We have a lengthy discussion in our papers about how the courts and the legislature has used the term rent loosely. And it means fair rental value of the property. Mr. King would have this court believe that rent in one section requires a lease, where rent does not require a lease in the next section, where it can't because it's in post-foreclosure cases. So that's how I view it, is just the word rent is used loosely as fair rental value throughout both
I have two
statutes.
questions for you. I'm sorry, Chief.
Go ahead.
In any event, the first question has to do with why is Judge Rubin wrong? And secondly, do you not agree with your brother that, in fact, as to Section 5, that there is only an application to the landlord-tenant law and not to post-foreclosure in 5? Don't you say that 5 doesn't apply because if it did, it would give the ability to waive. And you're saying that your first argument I thought was there's no ability to waive because Section 6, which is applicable, doesn't have anything like that. And so Section 5 should not apply. And it seems to me that your argument about why Section 5 doesn't apply is the same as your brother's argument that goes the other way, that Section 5 doesn't apply because, in fact, it only applies to landlord-tenant relationships, which is, I think, the same thing that Justice Rubin was saying. Isn't that right?
The word rent doesn't apply to just landlord-tenant.
I'm not saying rent. I'm saying that, didn't you say in the beginning, waiver? Let's talk about waiver.
The way that I look at it, the most logical way probably is to read the two statutes together. But if the court is going to apply a strict construction and not read rent consistently among the two, then we shouldn't even be under Section 5E, because Section 5E provides for a waiver of bonds in this section.
Yes, and in that section, you're saying it applies only to landlord-tenant.
That's right. So if there's going to be a strict construction of the statute, and we're going to look at it provides for a waiver of bonds in this section only. So then if we're not going to, the indigency waiver that requires a waiver of the bond, because one triggers the other. The two are inextricably linked. If you're going to waive a bond on account of indigency, it triggers an obligation to pay rent. But so if the court's going to read the two separately and rent doesn't mean the same thing, then you don't even need to look at Section 5E to justify what the housing court did, because the only obligation to waive on account of indigency is found in Section 5E.
And
So
it doesn't
then
apply
we're
because
still
it's
under
not-
Section 6.
And that only applies to landlord-tenant relationships, is what you're arguing, right?
Right, if the court's going to apply strict construction, it does. So then we're just left under Section 6, where there's no requirement to waive, and what the housing court did is fully justified by Section 6. Section 6 mandates a payment bond in the post-foreclosure context. And the payment bond that's required at the time of judgment has a back-in-time component and a component that goes forward. It requires a payment bond from the time of foreclosure until possession. So at the time of judgment, there's a back-in-time component. What the housing court did is waive the back-in-time component, and it required a component going forward, and it required a bond. It didn't call it use and occupancy or rent in it. It based the bond requirement on the fair value, which is appropriate, but it required those payments to be made into the court as security. They're not paid directly to the landlord. So what the housing court justice did is fully authorized and mandated by Section 6.
If I own a home and I am foreclosed and I remain in the home, what am I under our property law?
This court has not addressed this probably since the 1860s or 70s, but the appeals court has, lower courts have, the federal district court and the First Circuit have called it tenant at sufferance. There's really no other term, and tenants at sufferance are liable for fair rental value.
If I'm not a tenant at sufferance, I know there's some dispute, then what am I?
Maybe a squatter, but that would be if you entered illegally. You have to be something, and under no circumstance did the legislature intend for a party to occupy property without paying fair value. And one important distinction from the cases that Mr. King cites is that this is post-judgment. And post-judgment, the occupant's right to access the courts and have a trial has already been satisfied. And after a judgment, because King no longer owns the property and he was already adjudicated to not have a superior right to possession, at that point, the property owner's rights are paramount. It's required under their constitutionally protected property rights.
So if I'm sorry, if I can just finish. If I'm a tenant at sufferance, I have an obligation to pay fair rental value or reasonable rent, or what is the term that we use as to what the obligation is of a tenant at sufferance?
Fair rental value.
Okay, now does it matter when you say fair rental value that generally fair rental value implies certain obligations of the landlord in terms of maintaining the property, which may be different if I'm a tenant at sufferance than if I'm a leaseholder?
In some respects, and actually the plaintiff in this case has been obligated for some maintenance. For example, Mr. King has filed several motions with the housing court, even after judgment, to require my client to repair the roof of the gymnasium, and we've had to hire a structural engineer. So it's not entirely correct that we have no obligations. If the city is going to file a code violation action, it's going to name the owner of record.
So if I'm a tenant at sufferance, do you still have an obligation under the various covenants to?
Not under a lease, but under the state sanitary code. If there's an emergency issue, the courts have required the owner to take action. That's correct.
How about the warranty of habitability?
I think only if it goes to very important health and safety issues. Maybe not if the flooring is not correct or things like that, but if the heat is out in the wintertime, the housing courts have required the owner to take action.
And the covenant of quiet enjoyment?
I don't know. I think that's unclear at this point.
Okay, Justice Kafker, I'm sorry.
So similar questions to the Chief's question. So, this seems like we're dealing with a tenant at sufferance, right? Because we're post-foreclosure. These are really use and occupancy payments, right? This doesn't seem that different from Davis versus Comerford in many ways. It's a clear tenant at sufferance relationship because it's post-foreclosure. The word as rent or of any rent, neither of them are that precise. Are they meant to deal with use and occupancy payments? Is that what they're for?
I think it is use and occupancy payments. That's correct. Mr. King spends a lot of time in his brief trying to discuss how it's not a tenancy at sufferance and it's not use and occupancy, but this really is derived from, not from common law, from a statute that requires some compensation to the owner, which is consistent with constitutional rights. And the difference with Comerford makes a lot of sense. It makes those arguments that you're saying, those points that the occupant must pay fair value, and you adjust it in Comerford for various factors. But the difference in Comerford,
And that's where I was getting to with the chief's question. So in Comerford, we're adjusting the use and occupancy for fair rental value, but I'm trying to figure out, are we really incorporating all of these covenant of warrantability and all of this into this area now, when we're dealing with someone who's a sort of former owner of the place? I'm wondering whether all this applies.
the factors in Comerford may be relevant, but less so. At that point in Comerford, it's interim use and occupancy payments. At that point, the occupant of the property has not been afforded their full constitutional rights to a trial to have the matter heard in court, and where the court did not want to have a monetary barrier to someone being heard. This case is very different. It's post-judgment, where those rights have been satisfied and where the property owner's rights are paramount.
Excuse me, I thought you were arguing something different. I thought you were arguing both that it should not have been waived, and so you're entitled to a bond, which is different than use and occupancy, right?
It is. I mean, the
So
result is the same.
are you asking for both? Are you asking for the bond as well as for the use and occupancy payments? I can't really quite tell what you're arguing.
Well, some type of periodic payments. I'm not sure how the court wants to characterize, but what the housing court did was order bond
know what they
payments in
did.
the form of
I know what
fair
they did, but
value.
they waived the bond. They waived the housing court waived the bond, and you're basically saying the bond should not have been waived, aren't you?
If this court's going to apply a strict construction and read the statutes totally separately, where rent is not consistent throughout, then we're only looking at Section 6, where the bond doesn't even have to be waived. The court did waive the...
Isn't that your fault? I mean, that's not realistic, right? I mean, the amicus brief from, was it the Southeast, 5 and 6 are interwoven together, right? This is just your backup argument, right?
I think so. It is my backup, and that's why I'm saying rent should be read consistently. But if it's not, everything that the housing court did is justified, because he didn't order use and occupancy. He ordered bond payments into the court.
He did? He ordered
divided.
bond
He waived
payments?
the retroactive portion.
You ordered bond payments? I thought he ordered use and occupancy payments.
He did not, Your Honor. I mean, he ordered payments, periodic
But he waived
payments.
the bond. I thought he waived the bond. How can you waive the bond and then order bond payments as opposed to use and
He
occupancy?
did, and it depends how you want to characterize it. I don't know if it's form over substance or not, but he required payments into the clerk's office as security.
And that's what makes it a bond?
I think so, because it would be contingent on who prevails on an appeal. We would not get them unless we prevailed on...
Yes, but then they wouldn't be periodic, would they? I mean, a bond would be a bond. You know, you get a bond...
Correct. It provides a
an
security.
amount that the judge thinks is reasonable as security, and can condition it in whatever way he pleases, right?
Correct.
He doesn't have to set it at a high level, he could set it at a low level, but it would still be a bond and it has to be paid. And then he could also do use and occupancy, so I thought you were arguing.
Right. I mean,
But you're saying that's not what he did?
it's unclear. What the court did, he's ordered payments to the clerk's office as security for the appeal
And-
in an amount representing fair value of the property.
You couldn't do that with use and occupancy? You couldn't order use and occupancy payments to be made into the court?
I'm not sure about that, whether it would be called use and occupancy or not. As the court discusses in Comerford, under some circumstances, the payments can be made directly to the landlord if it's needed in order to make mortgage payments.
Can we
Right,
talk?
but there's a bit of a difference, just occurred to me, is that in the usual case, there's no doubt that the landlord owns the property. The claim here is that you don't own the property.
At this point, Mr. King just has an allegation. We've already been adjudicated at the trial court level to have a superior right to possession.
Right, but if he were to prevail on appeal, he prevails on appeal by showing that you actually do not indeed own the property. Correct?
That can't be done in the housing court. He would need to file a separate action in Superior Court, and he had every opportunity to do that. The housing court wouldn't make a decision as to validity of title.
So the housing court decision would determine only what then?
Who has a superior right to possession?
So play that out. So if he wins they or you still own the property, but he has a superior right to possession?
Right, he would need to file an action in another court to have the foreclosure deed vacated.
So it's already been foreclosed, so he doesn't, I mean, that may have been an error, that foreclosure action, but
So can I ask you how much, we're all sort of trying to get at this, and I think it relates to the nature of the relationship post-foreclosure, which is, you know, how much, whatever you call it, use and occupancy, as rent, whatever you call it, how much it is. I mean, I think that despite what the appellee's position might be at the beginning of the brief, they don't stay there for free any more than your Section 6 argument is, just as Kafka pointed out, that waiver and appeal bond doesn't apply under Section 6. They're both arguments out in the extreme. Seems like what the real disagreement about is if you look at 5E, if you have a waiver of the appeals bond, what's the amount of money? And the appellee's position is it's a reasonable amount considering the totality of the circumstances and the nature of the relationship, whatever that might be. And I'm wondering, once all the posturing's done, how much you disagree with that?
I don't disagree that once the bond is wavered, it actually triggers an obligation to pay fair value of the property. And what the housing court did in this case, it held an evidentiary hearing and heard my client had a higher amount that it submitted evidence on, and the court lowered that based on the fair value. And that's what's required to protect the party's constitutional rights. One case, the case that they cite, the Damascus case that this court decided in 1971, where they cited for where there can't be a monetary barrier to access the courts, that was an appeal of a zoning board decision to the Superior Court. And it would have been a bar to have it heard by any kind of a court. That's not what happened in this case. That would be like if Mr. King had to post a bond to file his answer and counterclaim.
But a fair market value is a pretty complicated thing. When someone takes a property by a foreclosure, you've got issues to deal with that you know you do. And as the Chief's questions were probing, what's the nature of the relationship? You don't have an obligation as it relates to quiet enjoyment, as you were suggesting you might not. The value of the property is elusive. And when you're looking at what that as rent might be if there's a waiver, you know, it's sort of complicated. And again, once all the posturing's done, I'm not sure how much you disagree on that issue.
Well, but don't they say that Judge Rubin said they're entitled to nothing?
I know, but that's like saying that the waiver of the bond doesn't apply to Section 6. That's as far out as that is.
Right, no, I
Fibrella,
agree
what do
with
you say, Mr. Fibrella?
For paying something how you decide it, just the basic carrying costs alone, the property taxes are almost $2,400 a month in this case. That's an important factor to consider. And what the court should also be considered is just the broader policy implications. Every one of these cases, cash for keys settlements will no longer occur anymore.
Cash for keys?
Yeah, so cash for keys settlements, Your Honor, there's a large percentage of these post-foreclosure summary process actions settle with the new owner paying the occupant a small amount of relocation assistance. And the occupant accepts that knowing that they're facing imminent eviction, or if they appeal, they have to pay fair value. That's been the status quo in the housing court for a long time. Without that, there's no obligation, there's no incentive for anyone to take that, move out, and pay rent somewhere else if they can just file a notice of appeal, see an appeal through, and stay in the house for another year or so. So that means every case is going to go to judgment, and every judgment is going to be an appeal.
Can I ask, if you win, and we determine that you're entitled to this as rent, what direction do we give on how that's calculated? Because this is a big property. So what do you want us to say if you win? In the last paragraph, you are entitled to fair market value as rent. How is that going to be calculated? And how do you take into account the issues the chief raised about warranty of habitability, et cetera?
In this case, we had a real estate broker who's familiar with properties in the area go in and do an interior inspection. We can't always do that, but we had to do it in this case because we had to inspect the structure of the gymnasium. Our broker was in there, and he provided an analysis with comparables of other properties. took photos, we introduced them to the judge. Mr. King had an opportunity to say that it was worth less than that, and the court credited some of that, and he discounted it $1,000 a month off of the evidence that we provided.
So the land court came up with a number? I can't remember. What did the land
Yes.
court, and what was the number?
$4,000 per month. We had evidence that it was worth $5,000. It was hard to compare because it's
And did it
quite
take
a lot.
into account the different issues the chief raised? About warranty of habitability, et cetera, et cetera?
Those really apply to promises under a lease, which doesn't exist here. I think that maybe that base, state sanitary code obligations are something that should be considered, because I look at it as, in these types of actions, when the properties are in disrepair and it's the former owner's still in it, the local code enforcement officials file actions and they name the new owner, the bank.
Can we assume that if something is selling for $4,000 a month, $48,000, renting for $48,000 a year, that it's going to meet warranty of habitability and covenant of quiet enjoyment requirements?
That's right, and I think that all of that can be taken care of, and what the housing court did in this case is hear evidence on the condition of the property. Mr. King introduced some evidence where there was some exposed wiring and some stains on the ceiling from leaking. So that was taken into consideration. And those are all factors that the court has in Comerford, but for what I said before, is this is post-judgment. So at this point, the property owner's rights have to take some greater priority than just interim before the occupant has a right to a trial.
Thank you, sir.
Thank you.
Mr. McArdle.
Good morning, Your Honors. If it may please the court. Attorney Luke McArdle on behalf of the defendant appellee, Alton King. And I really want to just jump into the actual terminology of the current statute. As with any question of statutory interpretation, we look first to the words of the statute and the language within the statute. And I think if you take a deeper look into the statute as is today and the amendments over time since the 1700s, it becomes a lot clearer. And I'll acknowledge that I don't think I pieced together the entire puzzle in my brief with the 3-week constraints to try to throw this together and provide a worthy submission to this court. The appendix, page 55 to 57, has the statutes, and I think if you take a look at it, the specific language that references sections or paragraphs or clauses within Section 5, if you take a look at those references, there's 7 references, not including the one to the indigent statutes. There's 7 references to provided for in this section as a whole, or provided for in specific sections, subsection C or section 6. There's 7 different references to sections. And if you really take a close look at the language, it becomes clear that every reference that says provided for in this section as a whole is inclusive of every summary process litigant, not one or the other. Section 5 cannot be read as separate from Section 6. It's the procedures for all summary process litigants. There was a distinguishing factor made between post-foreclosure litigants and landlord-tenant litigants that was specific because they understood that there was a different protection that needed to be made for those litigants, and that was the only distinguishing factor. And this goes back as far as 1888. If you look at I know I didn't provide this as an exhibit, but the Acts of 1808, chapter 325, you can look back that far, and it's the exact same language as it says in 5C now, where it says except as provided in section 6. That was there in 1888. In 1880, the language was the exact same. All rent accrued at the date of the bond and all intervening rent. Same exact language as it is today.
But none of this is rent. So I'm confused where you're going with this, because we're dealing with post-foreclosure, and it doesn't say rent, it says as rent, right?
Correct.
So, and then 5E uses the word of any rent. I can't remember what.
Yeah, a reasonable amount as rent, correct.
But we know we're not dealing with rent in the port. So your argument is just simply, if it's not rent by definition.
It's not rent, and I think if you look back at 1888, one was rent specific to landlord tenants, and one was something reasonable as rent.
But that doesn't make any sense if we're going to interpret the bond language in 6, does it? Because we're clearly, post-foreclosure, no one's paying rent, right?
Correct.
So why would, they clearly had a bigger concept in mind as rent, right?
I agree. That's what I'm suggesting as well. I think we're basically on the same page. What's that?
I don't know if we are, because I don't think you get to stay there for nothing.
Well, can I go to the bottom line as well?
Can I finish the question first? Yeah, just let me, I don't get what you're saying.
Okay, because I didn't really get to the full explanation of the references to sections, because then there's two specific references to only subsection C. At the end of paragraph D, there's a reference specifically to subsection, the third paragraph, subsection C, and then within the waiver bond, there's a specific reference to subsection C. Also within the waiver bond, there's three references to just this section as a whole. If you look at the difference, they specifically chose to reference subsection C specifically because it was exclusive only to rent and exclusive only to landlord tenants. The in this section, the other three references to in this section are inclusive of both Section 6 and Section 5E litigants. That was the point I was trying to make, and it becomes clear when you look at the different usage of those terms that one was inclusive and one was exclusive. One is inclusive of all litigants, and one was exclusive to just landlord-tenant Section 5C litigants. That was the point I was trying to make. And if you really look at that language in there, it becomes clearer and clearer once you look at that language. I think the rent issue that you brought up is also, when you look at the language of rent that's used 3 times in Section 5, twice in 5C and once in 5E in the waiver provision, it's clear they chose the word rent, and these amendments were made all the way there. Just to get into the amendments of Section 5, Section 5 has been amended dozens and dozens of times for the last 200 years. Section 6 has never been touched. Section 6 has been the same for hundreds of years. And if, as Bank of New York Mellon suggests, that Section 6 was supposed to sit in basically it sits in a vacuum. It wouldn't apply to, it would be inapplicable if it sat in a vacuum by itself, because there would be no procedures to even get to the bond condition.
I'm trying to, I really need to, for a moment, understand your bottom line here, because you're not, I understand your argument that this is not a landlord-tenant situation, and that the amendment to 5E and 5C seem to be talking about that. But you're not suggesting that your client just stay and use this property and not pay anything to stay until the litigation is over. I mean, is your bottom line, tell me if it isn't, is your bottom line that the standard when you're dealing with a foreclosure as opposed to a landlord-tenant relationship as to what the amount of money that needs to be paid is just different, and you have to take into account the totality of the circumstances, and that the actual fair market value actually might not be the correct number when you take into account the totality of the circumstances?
I agree and disagree at the same time. I disagree in the fact that I think the plain language of the statute suggests different protections, and there was no protection specifically added for a post-foreclosure litigant in the protection of the escape clause of the waiver to provide rent installments as they become due. Rent as they become due is specific to a landlord-tenant relationship, and I think.
So are you saying that Justice Rubin got it right?
Of course.
No, I understand it, but are you saying that his analysis is right? Is your analysis the same as his analysis?
My analysis is similar in the application.
Similar, it's not the same.
No, it's correct. It's similar in the application of her interpretation of the rent language not applying, but I don't even think you necessarily get to that. You do, but as I explained, the subsection language, I think, immediately removes Section 6 from the escape clause regarding after the waiver of the bond.
I don't understand what you're saying. I don't understand. I just don't. I'm reading this. I'm saying, aren't you just cherry picking? You know, you want 5E to apply in order to be able to get the waiver. The waiver bond gets waived, and then you say, okay, the rest of it doesn't apply to us because it only applies to landlord tenants.
It can appear to be cherry picking if you suggest that it was supposed to be it was enacted with that understanding, but I don't think it was. I think it's clear.
Do you have legislative history that you can tell us about that?
I do.
Where is that?
For one, if we look at the language, well, if you want to look at the legislative history, starting in 1888, 1969 was the first real amendment. The Acts of 1969, Chapter 366, was the first amendment that brought the waiver provision in. 2 years subsequent to that, in 1971, they specifically recognized that there was harm being done to landlords in these circumstances. If you look at Cargman v. Dustin and New York Bank v. Apollos, it specifically references the history of the statute and Cargman was decided in 1977 during these several enactments that were made over the course of that 10 years. So I think they have a better recognition of the reason why this new escape clause was added to protect the landlords.
Escape clause.
The escape clause from the bond waiver, the rent accrue, or the rent.
Is it, the waiver is the escape clause?
No, not the waiver is not the escape clause. The escape clause is that if you get the bond waived, then you're
don't have to pay any rent?
You're due rent going forward.
Yeah,
Correct.
so let's say that during the course of this litigation, that your client doesn't get to stay there for free. Okay? Just assume that for the moment.
Okay.
And then you go to Section 6, and shall be a reasonable amount as rent.
Right.
And I appreciate the point you made in your brief, as rent. So, assuming that your client doesn't get to stay there for free, based on the analysis that you've done, what's that number? And what goes into determining what that number is?
I think
The reasonable
I
number.
think that's an important question. If we get beyond my initial.
The bottom, yeah.
My
If we
initial
get-
argument,
If
you
we
get
get
beyond
beyond
that.
just staying for free,
Right. If we're going to say what's fair, yes, but I don't think it's for the determination of the court to decide what's fair if the statute's clear. But if we're going to decide what's fair,
statute's not clear.
okay, if the statute's not clear, we'll decide what's fair in a post-foreclosure setting.
But we're not deciding what's fair, we're deciding what the meaning of rent is.
Okay, and agreed. And I think it was implied to provide a lot of discretion, a reasonable amount as rent, something that is a monthly payment that is reasonable in the extraordinary circumstance that, extraordinarily different circumstance of a post-foreclosure setting. And I would suggest that all of the warranties that you suggested and discussed earlier have to be a part of it, because when you look at the HUD, a lot of these banks come in with just a printout from HUD that says this is a 2-family, 3-bedroom. This is how much market rent is worth. But this is market rent for a fully functionable, perfect conditions of the lease, warranty of habitability, sanitary code. Everything is included in market rent, so that can't be the starting point. I guess it could be the starting point, but they can't even be close to the end point. And I think
But did the land, if we don't agree with Justice Rubin's position, in the appeals court position, in the land court, we revert to the land court, is there something wrong with the land court's $4,000 a month calculation? What is it?
yes, because it's solely determined off of market value for a real.
So if you win Justice Lowy's compromise, how would the last paragraph of our decision read? Meaning we got to remand it to the land court to redo what on that $4,000?
I think that the Comerford case is a good starting point. There needs to be factors that offset whatever the starting point is, it needs to offset. But in my opinion, I think if we're going to abide by the indigency laws in general and provide these persons an opportunity to appeal these cases with an incredible property right at stake, and you look at the indigency waiver and you clearly see that this person the bond's going to be dismissed, the appeal is going to be dismissed if you can't make.
Very hard to do an indigency analysis on someone who is living in a house that's worth $4,000 a month. How do we do that?
It's challenging, admittedly so, and I would suggest that the carrying costs should be the ceiling, as I suggested in the brief, because those are ownership interests. You're paying the insurance, you're paying the taxes because you're disputing that you're the owner. These are carrying costs that you would pay as an owner.
Is that the floor too?
Carrying
costs can't be less?
I don't think it should be the floor. I think it should be the ceiling. I think you then look at the individual, the hardship. In this case, my client is currently an elderly man going through cancer treatments. The property is worth $1.6 million. The bank got it back for $1.2. They have $400,000 in basically a windfall to protect themselves in any case. And I know this is specific to this case, and it's not the same with all the cases. But there's protections. The protections are born into a mortgage. These costs are borne into a mortgage, the foreclosure costs and repossessing these properties.
Speaking of the mortgage for a moment,
Yep.
can you just direct me, I don't know if it's in the record or not, I don't see it, where in the documents it would say that if there's a foreclosure, payments stop to the lender?
It's not in the, yeah, I mean, once you foreclose a
Once
mortgage,
you-
that's
so-
your
So
remedy.
there's just, but if the remedy is what?
The remedy is foreclosure of
The
the
remedy
mortgage.
is foreclosure,
Yeah.
but
And then auction.
if the homeowner or the former homeowner is not leaving
Mm-hmm.
and is disputing that foreclosure, does that not change the calculus? And wouldn't that not make the mortgage still payable? Or is that an incredibly stupid question?
It's an interesting question, but I mean, I think the remedy of the mortgage.
After thinks it's an incredibly stupid question.
No, I just think it's interesting.
Yeah, the remedy of the mortgage, once there's a default, is to foreclose, to auction it off, to
Right.
take whatever proceeds are available. If there's a deficiency, you're able to chase the deficiency.
But one party is not agreeing to that, so why isn't that party still held under the agreement of the mortgage?
I think it's just a contract-based. The contract is now nullified. It's basically voided. Once it's
So
foreclosed,
the
it's
foreclosure
nullified.
nullifies the contract, the
Correct.
terms of it?
So if you win, if you were to win on your appeal, because you said paragraph 22 of the mortgage was not complied with by the lender.
Correct. I'm
You
very
win,
confident.
Then what do you get?
Then you get a rescinded foreclosure.
Yeah, and so you get but you take it mortgage-free?
No,
And
no,
what-
it's still subject to the lien.
So then you have to
but-
pay the mortgage payments,
But then he
right?
has an opportunity to potentially sell the property because there's potential
All right,
equity.
but I
So
mean,
that would put
meanwhile,
him
you still have to pay the mortgage payments, right?
he would definitely have to pay the mortgage
Pay
payments.
mortgage payments in the period of time that the appeal was pending, too, because you, right?
I don't know how exactly that works. That's a good
well.
question.
But isn't the problem with your capping with the carrying costs is that has nothing to do with the word rent? You know, you may win on your rent argument, but something has to equate to rent for all of this to make sense.
Right.
So I don't understand how we get the carrying costs, because carrying costs are never rent, right?
Carrying costs are never rent. No,
So
carrying
we
costs
can't-
is
Your
less than
idea of
rent.
capping with the carrying costs, I think we got to come out with a rent proposal somehow.
Well, I mean, I think we can agree that the as rent is removing it from the actual true definition of what rent is, and they chose that language to kind of come up with a
But then there's
discretionary as
the
rent.
clause you like is of any rent or whatever the second clause, which sounds more like rent.
Right, correct. It's hard to say exactly where to go with that, because I don't think rent was ever meant to be applied to a post-foreclosure litigant in any sense of the word. And one last point regarding the language in the statute, I was saying they used the term rent three times. They also used the term periodic payments 3 times. And I just want you to take a look at the difference between when they use the terms periodic payments and the terms rent. Periodic payments, again, is an inclusive term that includes rent, use and occupation, monthly payments, whatever you want to call it. It's an inclusive term. Rent is a specific term. And they could have utilized periodic payments where they put rent, and rent where they put periodic payments if they wanted to specify it relating to each scenario and each distinguishable scenario with the landlord-tenant and a post-foreclosure litigant.
Before you sit down, your brother says that your client is a tenant at sufferance. What do you say your client is right now?
If my client was to be called a tenant at sufferance, it wouldn't be a tenant at sufferance in regard to a landlord-tenant scenario. A tenant at sufferance has been defined by this court as a tenant who no longer has an active or binding or controlling lease agreement, but previously entered the property upon a binding lease agreement, which was terminated at some point, and now they're a tenant at sufferance because they're operating against a former agreement. But that's the
Sounds awfully
definition.
like what's going on here.
It's similar, but if a tenant at sufferance in this context would more be a tenant in common or joint tenant at sufferance as a disputed property owner rather than disputed possession owner or possessory interest. So I think that's.
But again, if you give us an answer, because I think the chief's question really would help us. Is there another thing we can turn to besides tenant at sufferance to describe what your client is?
That was one of the suggestions I made in my brief, that there should be some clear terminology regarding what a post-foreclosure litigant in this situation is called, because there's so much confusion and.
But one of the beauties of property law is you've got 1,000 years to look at. Do we have any,
There's nothing that I've seen, other than some references to tenant sufferance, but then this court has also kind of clarified.
There are cases in which someone who owned the home, who's been foreclosed on, who's still living in the house, is referred to as a tenant at sufferance?
There is, yes.
So that's the best example.
That's the best example, but I think this court has also tried to clarify that there's a difference, and what the underlying original defining characteristics of a tenant at sufferance were meant to be.
Well, what you're saying is that generally a tenant in sufferance is somebody who is lawfully there pursuant to a lease, and then now the lease is expired.
Correct.
But your client was lawfully there because he owned the property.
Correct.
And now no longer arguably owns the property. That's in dispute.
Correct.
So can you figure out a better name than tenant in, we have these
Probably
categories, as Justice Kafka noted, over 1,000 years. It is somewhat unusual. It's not as if a foreclosure was just invented last year. We have no name to characterize what your client is under the law?
A disputed owner?
Okay, well, of course, you could be a disputed owner if you didn't live there, too.
He could be, correct.
But you're a disputed owner who happens to still...
Disputed owner in possession?
Disputed owner in possession. Okay, thank you.
Thanks so much.